All right, welcome to This Explainer. Today, we're going to completely decode the invisible laws that govern pretty much everything we create, buy, and interact with on a daily basis. We are, of course, talking about intellectual property. It's really like an invisible shield that protects the apps on your phone, the blockbuster movies you watch, and even the highly distinct look of your favorite local coffee shop. We're going to map out exactly how this hidden matrix of laws works to protect those products and brands you interact with every single day. Here is our roadmap for today. We're covering 1, protecting your ideas, 2, the anatomy of trademarks, 3, infringement and dilution, 4, the IP comparison matrix, 5, enforcement and remedies, and finally 6, global intellectual property. Let's just jump right in. Section 1, protecting your ideas, the value of creativity. There's this fantastic kind of playful quote from the author Jared Kintz that perfectly grounds us in the right mindset for this topic. Historically, property was just about physical survival, land, crops, livestock. But today, intellectual property, whether that's a creative work or a brand identity, is a very tangible asset. It might seem totally abstract, maybe even like a stable of unicorns, but in the eyes of the law, it is property just as real as a plot of physical real estate. And trust me, it carries absolutely incredible economic value. Moving on to Section 2, the anatomy of trademarks, brand DNA. So what's really fascinating about the legal definition of a trademark is that it actually goes way, way beyond just a familiar logo. A trademark can quite literally be a sound. Think about the famous booming roar of the Metro-Goldwyn-Mayer lion right at the beginning of a movie. That sound is legally protected intellectual property. The whole point here is to distinctly identify the source of the goods, ultimately so that consumers, like you and me, are not confused about what we're buying. Think about something as simple as a classic Coca-Cola vending machine. Familiar brand names, iconic logos, and even the specific ornamental designs of things like vending machines are fiercely protected by statutes like the Lanham Act. The law actively seeks to avoid confusion. Think about it. If another totally unrelated company just slapped a really similar script logo on their own red vending machine, it would trick consumers into believing those drinks were actually made by Coca-Cola. But here's the catch. Not all trademarks are created equal. The law actually classifies them on a distinctiveness spectrum. Right at the very top, you have fanciful or arbitrary marks. These are entirely made-up words with no direct logical connection to the product, and they get the absolute strongest legal protection. Moving down the line, we have suggestive marks, which require consumers to use just a little bit of imagination. Think of Dairy Queen for ice cream. Below that are descriptive marks, which actually need a secondary meaning, usually through extensive advertising, just to get protection. And at the very bottom, generic terms. If your mark just broadly describes the product itself, it gets absolutely zero trademark protection, no exceptions. And this logic brilliantly illustrates a broader concept known as trade dress. Trade dress refers to the image and overall appearance of a product. Take the highly specific purple and orange color combination on a FedEx delivery truck. A competitor named JetX once tried to use that exact same color combination, a very similar logo, and even mimicked FedEx's "The World on Time" slogan. Well, what do you think happened? A federal court shut JetX down immediately, blocked them from using those colors, and made them pay attorney's fees. Why? Because that overall look and feel, that specific trade dress, belongs exclusively to FedEx. Which brings us to Section 3, infringement and dilution, protecting the mark. Let's look at a hypothetical scenario to see how this plays out in the real world. Imagine a company called JD Beverage creates a highly successful, trendy line of flavored vodkas called Hot Lips, complete with a registered stylized puckered lips logo. Sales are absolutely booming, but suddenly a competitor launches Kiss Vodka, and they're also using a puckered lips logo and a super-similar marketing theme. Because of this, JD Beverage starts losing major sales. This is a classic marketplace conflict. So what can JD Beverage do? Well, they can sue for trademark infringement, arguing that the competitor is stealing their distinctiveness and causing massive consumer confusion. So the crucial takeaway here is understanding the difference between infringement and dilution. Infringement absolutely requires a likelihood of consumer confusion, like someone buying Kiss vodka actually thinking it's Hot Lips. Trademark dilution, though, is completely different. Dilution just requires an unauthorized use that impairs a famous mark's distinctiveness or actively harms its reputation, and get this, even if the products don't compete at all. A great example, Hasbro, the maker of the wholesome children's board game Candyland, successfully sued a sexually explicit website that tried to use the Candyland domain name. Obviously, no one was confused, thinking Hasbro made the explicit cite, but the court stopped it anyway because it diluted and severely harmed the family-friendly Candyland brand. And as you might guess, in our digital age, these protections extend directly to the web. Congress actually enacted specific laws to stop something called cyber squatting. This happens when bad actors go out and register a domain name that is identical or confusingly similar to someone else's trademark with a bad faith intent to profit. Usually they do this by holding the domain hostage and trying to extort the rightful brand owner by selling it back to them at a massive, massive markup.
All right, Section 4, the IP comparison matrix, the big picture.
I absolutely love building out this matrix because it gives us a clear, visual comparison of the four main pillars of intellectual property we're introducing today. As we've just seen, trademarks protect the distinctive symbols and words that identify a brand. Patents, on the other hand, are exclusive government grants that protect actual inventions, designs, and novel processes. Copyrights protect the expression of literary or artistic works, so we're talking books, music, and even software code. And finally, trade secrets protect confidential business information that gives a company a competitive advantage, things like private customer lists or unique manufacturing methods. Now, what's really fascinating here is how the lifespans of these protections wildly differ from one another. A patent actually expires after just 20 years. Why so short? Because the government actively wants to encourage public innovation. After 20 years, that brilliant invention enters the public domain for anyone to build upon. A copyright lasts quite a long time, usually the life of the author plus another 70 years. But trademarks and trade secrets, this is crazy. They can technically last forever. They are unlimited in duration as long as the trademark remains in continuous commercial use and as long as the trade secret is, well, actually kept a secret. Next up, Section 5, Enforcement and Remedies, when rules are broken. So, we know how long they last, but what legal hammers do courts actually use when these rules are broken? Well, if you steal a trademark or sell counterfeit goods, the courts come down incredibly hard. A judge won't just issue a polite injunction telling you to stop, and they won't just make you pay actual damages plus any profits you happen to make. The court will order the active forfeiture and literal physical destruction of the counterfeit infringing articles. And to top the whole thing off, you'll very likely be paying the brand owners incredibly expensive attorney's fees as well. And believe it or not, the penalties for stealing the other forms of IP can be even harsher. If you intentionally infringe on a patent, the court has the power to actually triple the damages you owe. For the willful theft of trade secrets, heavy punitive damages are absolutely on the table. And for copyrights, in addition to massive fines and statutory damages, serious copyright piracy, even if you didn't personally make a profit, like freely distributing pirated movies online to your friends, can lead to literal prison time. Finally, Section 6, Global Intellectual Property, Worldwide Shields. Because the United States leads the world in producing creative products and IP, international protection is completely vital. The most significant, far-reaching agreement out there is called the TRIPS Agreement. Signed by over 100 nations, TRIPS essentially forces member countries to establish broad intellectual property rights within their own domestic laws. And most importantly, it forces them to provide real legal teeth, effective civil and criminal remedies to protect creators worldwide. It really sets the baseline standard across the globe. Which brings us to our conclusion. We've successfully mapped the IP metrics today, from trademarks and trade dress, all the way to patents, copyrights, and the fierce real-world remedies used to enforce them. But the final thought I really want to leave you with today is this. In a digital world where an image, a sound, or a complex piece of code can be instantly copied and distributed globally in a millisecond, are your own creative assets and business ideas fully protected? I highly encourage you to take a hard look at your own projects through the lens of this newly decoded IP matrix and make sure your stable of unicorns is properly secured. Thanks so much for joining me on this explainer, and keep learning.